or counterpart funding to pay or rather compensate the project affected persons.
Thank you very much,
and
Right Honourable Speaker.
To acquire
Madam
the
Speaker, for the
way
record,
leaves. The budget
this
committee
morning,
has allocated.
I made a phone call to the
government
chairman
and
of Legal and
finance
Parliamentary
has allocated
Affairs
26
Committee,
billion
and I
to
told him
Oreo
on the phone
mini
that I have a
hydropower
minority and the
plant.
chair is here.
Couldn't you consider reallocating
Secondly, when
nearly
I reached
20
Parliament,
billion
I again
to
notified
unlock?
him.
This is
on
an
our
urgent need
platform,
to
and then
unlock
I filed this
this
report with the clerk of our
345
committee, who duly
billion
submitted to the clerk of
for rural
Parliament,
electrification
and duly
operation
stamped
is
and
to
received.
resume.
So the record should show that
Madam
I am
Speaker,
not struggling, I'm just complying.
I would have loved to proceed, but this is a very important keynote
Madam
observation
Speaker,
that I've made in the main
Before
report,
I read, I
which is
beg these two situations
a universal.
to bear with me. First of all, as Honorable
No.
Chair rightly observed, the opposition, my boss, has led a walkout as Shadow Minister for Justice and Constitutional Affairs. You can imagine the situation. May finish and I get fired. So allow me present this report here. Secondly, in times like this, you would beg that me during the ruling court at myself and many others against the Attorney General, when their lordships had judged 3 against 3, the last judgment was by the Chief Justice Bat Katurebe, and when he had begun to read, he informed us that his glasses and the eyes had a problem and he needed to be rushed to South Africa immediately. I pray when I'm reading this report, my glasses don't fail me. Having said that, Madam Speaker, introduction. This is a minority report in dissent of the majority report of the Joint Committee of Legal and Parliamentary Affairs and the Committee of Defense and Internal Affairs on the Uganda People's Defense Force Amendment Bill 2025. This minority report is brought under Rule 215 of the Rules of Procedure of Parliament, areas of dissent and statement of reasons for dissent. The minority restricts the areas of dissent majorly on the policy and principles, defects in the existing law, remedies proposed in the bill, and specific provisions of the Uganda People's Defense Forces Amendment Bill 2025, touching the courts martial and related matters, including the schedules. Approach. In this minority report, it presents specific thematic areas of dissent, the reasons for the dissent, and explanatory statements for the reasons of dissent, and this minority report is guided by the provisions of the 1995 Constitution of the Republic of Uganda, the applicable subsidiary legislations, and the lead judgment in the Supreme Case, Attorney General versus Michael A. Kabaziguruka, Constitutional Appeal number 2 of 2021. Therefore, Right Honorable Speaker, each word, sentence, paragraph in this report has been carefully considered by the minority for justifying the dissent from the main report of the committee. The minority prays that time be allowed for this report to be presented to the House, both verbatim and seriatim. Thank you. Preliminary and substantive discussions on points of law. In this report, the minority raises several points of law in both preliminary and substantive forms. The minority submits that meaningful debates and decisions of Parliament can only take place after the presiding officer has disposed of, by way of a formal ruling, with reasons, all the points of law raised. The presiding officer should not be tempted to sweep under the carpet, fail, or casually dismiss these important issues of points of law raised by the minority. In short, the minority invites the full attention of the presiding officer during the presentation of this report and prays for the rulings to be delivered on record in a timely manner before debate ensues. breach of Rule 75 of the Rules of Procedure of Parliament on sub judice. During the consideration of the bill, the Uganda Law Society brought to the attention of the committee and Parliament an active court case in the East African Court of Justice, which court decisions are binding on Uganda as set out in the landmark precedent case of Among A. Anita versus Attorney General of Uganda and another, reference number 6 of 2012. I produced the letter dated 14th May 2025, and it is addressed to the clerk to Parliament and reads as follows. Reference, the Uganda People's Defense Amendment Bill 2025. Greetings from the Council, management, and staff of Uganda Law Society. In response to your invitation to meet the Joint Committee on Defense and Internal Affairs and Legal and Parliamentary Affairs for consideration of the above captioned bill, for which we are grateful, this is to inform the Joint Committee as follows. 1. The Uganda Law Society received your invitation letter today at 11:50 a.m., scheduling a meeting for 12 p.m. on the same day. With the greatest respect, the time frame is manifestly inadequate for a thorough consideration of the 150-page bill and is incompatible with democratic accountability. 2. Be that as it may, the Uganda Law Society hereby brings to your attention reference number 14 of 2025, Uganda Law Society versus the Attorney General of the Republic of Uganda, pending before the East African Court of Justice. Discussing the bill's provision on military courts would inevitably breach the sub judice rule, contrary to Rule 75 of the Rules of Procedure of Parliament of Uganda, Statutory Instrument number 43 of 2025, and Article 38, Sub-Article 2 of the Treaty for Establishment of the East African Community, and potentially contravenes Articles 2, 20, 79.3, 92, 126, 1, 128.3, and 287 of the Constitution of the Republic of Uganda. 3. Given the pending litigation, we respectfully request the Joint Committee to urge government to pursue amicable resolution of the dispute before engaging Parliament and on the contested matters. The Uganda Law Society welcomes the opportunity of another invitation to discuss the rest of the bill. Yours, it is signed by Ewan Asimwe, who is the Vice President of Uganda Law Society. I don't know for what reason why the President is able to sign. I now beg to lay on table the copy of duly received by the Office of the Clerk, as well as a copy of the reference number 14 of 2025, Uganda Law Society versus the Attorney General of the Republic of Uganda. Madam Speaker, this document is already part of the minutes laid by the committee. If it's not there, I have a copy that I can lay. In the same vein, the minority also draws to the attention of the Right Honourable Speaker of Parliament and Parliament the constitutional application number 01 of 2025, Male Mabirizi K. Kiwanoka versus the Attorney General, filed in the Supreme Court of Uganda on 14th April 2025. And the same has been duly served upon the respondent who is present in this sitting. The gist of that application is that the Supreme Court should determine whether the action of the respondent General and government and parliament of proposing and consideration of the Uganda Defense Forces 2025, providing for trials of civilians in the courts martial, is contemptuous judgment of the Supreme Court in Uganda, in Supreme Court of Uganda, in Attorney General versus Michael, which I have already. The constitutional application number 01 of 2025, as referred, filed in the Supreme Court, has already been duly served. The respondent, the Attorney General, is present in this House and can confirm or deny the existence of this live case. All that the minority is belaboring by this submission is to demonstrate by all standards that there is a live and active dispute, not only before the East African Court of Justice, but also Uganda's highest court, the Supreme Court. It will be quite embarrassing for Parliament, an institution central to democracy and the rule of law, to carry on with the consideration of the Uganda People's Defense Forces Amendment Bill 2025, well aware of the court cases that touch on the subject matter of in the bill. The finding of the minority. The minority finds that Parliament proceeding to consider the clauses of the UPDF Amendment Bill 2025 touching the subject matter of trial of civilians in the undermines the core tenets of the rule of law, the doctrine of mutual respect for separation of powers between the executive, legislature, and judiciary. The next is on retrospectivity of legislation, contrary to Article 92 of the Constitution of Uganda. Article 92 of the Constitution of the Republic of Uganda on retrospective legislation states as follows: Parliament shall not pass any law to alter the decisions or judgments of any court as between the parties to the decision or judgment. Decisions or judgments of courts are categorized into two: one in personam and two in rem, to mean against a person and the world at large. The considered opinion of the minority, that judgment in Constitutional Appeal number 2 of 2021, Attorney General versus Michael K. is firmly binding on the movers of the bill as well as this Parliament. In short, unless Parliament is deliberately and with utmost impunity dismissive of the judgment of the Supreme Court of Uganda, which judgment was led by none other than Honorable the Chief Justice of Uganda, Alphonse C. Owindolo, together with his brother and sister lordships of the court, the Honorable Lady Justice Catherine Mereire, the Honorable Lady Justice Monica Kalejera Mugenyi, the Honorable Lady Justice Faith Mwanda, the Honorable Lady Justice Elizabeth Musoke, the Honorable Lady Justice Percy Knight Tuhaise, and the Honorable Justice Mike J. Chibita, who did an splendid job. And I know who are still that when you get children, you can in Uganda. We surely don't wish to be the midwives to deliver this baby at all. Madam Speaker, let it also sink in our minds that at one point soon in our lifetime, Uganda will have another president other than H.E. Museveni. The next president, as per the law, shall be the chief boss of the court martial. This House may have already noticed the following names in no particular order of chances of being the president, being discussed in the main as potential future presidents starting in 2026 and beyond. the Honorable Akena Jimmy James Michael Obote, the Honorable Chagulanyi Sentamu Robert, the Honorable Amuriat Patrick Oboy, General Kaino Rugaba Muhozi, General Mugisha Muntu, Honorable Norbert Mau, Right Honorable Aneta Mau, Colonel Retired Dr. Kiza Warren Besige.
Honorable, I never wish to be a president. Remove my name from that list. I am satisfied with what I have, and I'm even getting out of politics. Don't put my name into this.
Madam Speaker.
No, my name is not for playing. My name is not for jokes.
Madam Speaker, allow me, since it's a one.
Please, my name is not for jokes. I never want.
Yes,
Honorable, it is my name.
Madam,
please remove it.
Yes, this is a one-member's report signed by me, and I can amend it. I want to withdraw. That's what the point I want to make.
Yeah, withdraw. I'm not part of that.
That although I had said that the names were in the public domain,
public domain.
I beg to withdraw.
I have my own right.
I beg to withdraw and delete and amend this report by deleting the name Right Honorable Anita Among Annette from this report. And I accordingly withdraw and apologize to you, Madam Speaker. Please, the record does it. Please, I invite this House to carefully reflect on each one of them, their soberness, fidelity to the law, ideologies, actions, sentiments, service records, and imagine what each one of them is capable of using such provisions in the bill. The finding. The minority finds that legislating on clauses of the bill that touch on the decision of the Supreme Court, specifically enacting clauses to try civilians and soldiers who commit civilian crimes in the court-martial, contravenes Article of the Constitution of the and amend this report by deleting the name Right Honorable Annette from this report, and I accordingly withdraw. And Speaker, please, I invite this House to carefully reflect on each one of them, their soberness, fidelity to the law, ideologies, actions, sentiments, service record. Imagine what each one of them is capable of using such provisions. The finding. The minority finds that legislating on clauses of the bill that touch on the decision of the Supreme Court, specifically enacting clauses to try civilians and soldiers who commit civilian crimes in the court-martial, contravenes Article 92 of the Constitution of the Republic of Uganda, in light of the case of the Attorney General versus Michael K.K., Constitutional Appeal number 2 of 2021. The next is dissent is understanding of the judgment of the Supreme Court in that case. Right Honorable Speaker, during the consideration of the bill in the committee, an issue arose as to whether there was a lead judgment to inform the consideration of the bill, or all judgments of the quorum mattered. The learned Attorney General informed the committee that the judgment of Honorable the Chief Justice, as is the lead judgment, whose final orders and recommendations guided the drafting of the bill. Whereas the minority considered the other judgments as equally important, in as far as several rulings therein, the minority, for purpose of harmony, agreed with the Attorney General to restrict discussions around the lead judgment of Honorable the Chief Justice, Alphonse C. Owindolo, who 6 specific issues that the Supreme Court was required to resolve, and the issues are as follows. The first was whether the court-martial are courts established under the Constitution or are mere tribunals. 2, whether the court-martial can be or are independent and impartial within the meaning of Article 28 of the Constitution. Whether civilians can legally be liable to face trial in the court-martial for disciplinary offences, herein called military, disciplinary or service offences, stipulated in Part 6 of the UPDF Act. 4, whether citizens can constitutionally or legally be tried in the courts-martial for civil offences offenses not comprised in Part 6 of the UPDF Act, but are instead provided for in other legislation. 5. Whether it is constitutional for persons subject to military law to be tried in the court-martial for offences outside the UPDF for civilians to be tried by the court-martial as principle for offences. Sections 1191H of the UPDF Act exists in the civilian each of the questions. As this will secondly and most importantly now section of the UPDF Act, which establishes the General Court Martial established under the law as a competent court, is constitutional. Our understanding of the above declaration is that it is duly established under the law and its existence with the Constitution. However, it must be clothed with the following. A. Members of the General Court Martial must be persons with legal qualifications. B. The members of the General be independent of the command and have tenure. C. There should be adequate time and facility in the preparation of defense by an accused person, as well as the right of an accused person to due process and an appeal in capital offences. D. The convening.
Okay. That's the worst day ever. (1191) now respectively 177, 10X, 117, and G of the UPDF Act are unconstitutional since the conviction on court-martials to try civilians. Our understanding, the understanding of the Attorney General of this declaration and 9 by the court is that civilians cannot be tried in military. Our understanding of this declaration 7, 8, and 9 by the court is that civilians cannot be tried by military courts. I quote from the Attorney General. The minority recognizes the mandate of the Office of the Attorney General under Act 9, 3 and 4 of the Constitution of the Republic of Uganda, to which shall be the principal legal advice of government, to give legal advice and legal services to government on any subject. It may be recalled, Right Honorable Speaker, that in both regional constitutional petition number 45 of 2016, Honorable Michael A. Kabaziguruka versus the Attorney General in the Constitutional Court, and in the Constitutional Appeal number 2, 2021, the Attorney General versus Honorable Michael K. The Attorney diligently and professionally offered legal services, representation in court, and lost all the arguments except the legality of existence and creation of the court-martial. However, how then does the executive and even Parliament expect the same learned Attorney General to again go back to the court and Supreme Court to defend the same issues which he argued and lost? It must be very burdensome, tiresome, hopeless, and frustrating to be lawyer to the government in such scenarios. Sympathies to the learned Attorney General, Honorable Kriwa, and the team of learned friends in the chambers of the Attorney General who prosecuted the case. Can they face the same court again on the same issues already decided by court? They must will have been informed, asked to be excused from executing role of Attorney General. Then a Deputy Attorney General who was with us here, Honorable Mwesiga Rukutana, immediately he left this and he had the energy to marry even a young wife. So it is really burdensome, Attorney General.
Honorable Duru, you're going personal. Please.
I withdraw.
She has, I mean, what's wrong with marrying your wife?
Finding.
Huh?
I withdraw. Finding. The minority, therefore, finds that there is no basis to provide for trial of civilians in the military court as decided by the two highest courts of Uganda, Constitution and the Supreme Court. The minority further finds that there is no political, ideological, and security narration to justify to provide for trial of non-military offenses in the court-martial. Therefore, is shallow, unreasonable, and unconstitutional. Court-martials by the Supreme Court are established legally, hence there is no need to re-establish it. Court-martials as found by the Supreme Court, and this is what I have to pay attention to, are already established legally, hence there is no need to establish it. The question of restructuring of the court-martial is necessary, be later pointed out, not possible through provisions of the proposed bill. Subordination of the court-martial. That's the next of dissent. The Honorable the Chief Justice, Alphonse Owindolo, in his judgment, found as quoted below. I open the quote. Additionally, as already noted, the General Marshal and other military courts are all subordinate courts. See the case of Attorney General versus Uganda Law Society, Constitutional Appeal, number 1006. However, I do not agree with Justice of the Supreme Court's finding, where he held that the General Court is subordinate, but not lower than the High Court. According to the Black Laws, Brian A. Garner, 8th edition, subordinate means play it in or belonging to a lower rank, class or position, or subject to another's authority or control. Assigning the ordinary English meaning to the ordinary.
Potential to create an absurdity when it comes to hearing of capital offences. If Parliament desires to grant them jurisdiction to handle capital offences, then it would need to do so in line with the Constitution. The minority observes, Madam Speaker, that Article 129 of the Constitution of the Republic of Uganda provides for the courts of judicature as stated in the judgment. Article 129.1, the judicial power of Uganda shall be exercised by the courts of judicature, which shall consist of A, the Supreme Court of Uganda, B, the Court of Appeal of Uganda, C, the High Court of Uganda, and D, which is underlined, such subordinate courts as Parliament may by law establish, including the Cadi's Court for marriage, divorce, inheritance of property, guardianship, as may be prescribed by Parliament. Article 129 of the Constitution is on the jurisdiction of the High Court and states as follows, and we can read together. 1. The High Court shall, subject to the provisions of this Constitution, have unlimited original jurisdiction on all matters, and such appellant and other jurisdictions as may be conferred on by this Constitution or other law. In light of the judgment of the Supreme Court, Madam Speaker, any court created by Parliament is inherently subordinate to the High Court. Any court created by this Parliament, whether we go ahead and create or not, is inherently, by this provision of the Constitution, subordinate. We cannot create a court equal or higher. For any court to be created with either the same or higher jurisdiction to the High Court, it has to be directly created in the Constitution under Article 129, sub-article 1, and listed either in, you can reflect, in clause 1C with the High Court, meaning at the same level, or immediately before clause 1D to exclude it from the subordination. The minority also observes further that conferring unlimited jurisdiction on courts created under Article 129, other courts other than the three courts of record. The minority also observes further that conferring unlimited jurisdiction on courts created under Article 129D, which we are about to do, of the Constitution is equivalent to amending Article 139, Sub-Article 1 of the Constitution, to the extent of creating exceptions limiting the already unlimited original jurisdiction conferred by the Constitution of the High Court. I can repeat that. The minority observes further that conferring unlimited original jurisdiction on courts created under Article 129D, such as the court-martials of the Constitution, is equivalent to amending by infection Article 139(1) of the Constitution to the extent of creating exceptions limiting the already unlimited original jurisdiction conferred by the Constitution on the High Court. Is it therefore allowed to amend the Constitution through an amendment of an Act of Parliament? The obvious answer is no. The Constitution can only be amended in conformity to Chapter 18, Articles 259 to 263 of the Constitution of the Republic of Uganda. The minority submits that the UPDF Amendment Bill 2025 is not a bill for an act to amend the Constitution, and therefore cannot attempt by trickery or any other means, including fraud, purport to amend Article 139 of the Constitution of the Republic of Uganda. Right Honorable Speaker, the advisory order recommendations of the Supreme Court are stated in paragraph 10 on page 199, bullet E of the judgment of the Honorable, the Chief Justice Alphonse C. Owindol as follows. E, amend the Constitution, and pay attention, this is what the Chief Justice ordered or recommended. Amend the Constitution to establish superior courts within the military court system under Article 129, and clothe those courts created by amendment of the Constitution with the requisite jurisdiction and guarantee of independence and impartiality to try specific military offenses under existing laws committed by military personnel. F, the Chief Justice advised, provide in the UPDF Act for the High Court, which is already created and in existence, to sit as a court-martial with power to try all criminal capital offenses within the High Court's jurisdiction, and those unique to the military that attract maximum of life and death sentences. Grant the Chief Justice powers to assign judges to the military courts. A select number of military personnel can therefore act as assessors. Appeals to the court-martial appeals court would follow the same format, with Court of Appeals sitting as such. Magistrates' courts would assume the jurisdictions all over other offenses of a subordinate court. G, the Chief Justice says, make provisions in the UPDF Act for trials of civilian in the military courts to be only under limited circumstances, and only after the state concretely demonstrates to the court by verifiable facts and by objective and serious reasons the need and justifications for recourse to the military courts. This must only apply where, in relation to the specific class or category of persons, offenses in question, ordinary courts are not in position to undertake. This is the quote of the Chief Justice upon which this bill has been brought. The understanding of the minority on these advisory orders E to F and G above is that they are premised on the fact that all trials of both civilians and military personnel who commit non-service military offenses must be before civilian courts. In other words, the current civilian courts, Magistrates' Court, High Court, Court of Appeal, and Supreme Court are all competent by all standards required under Article 28 and 44 of the Constitution of the Republic of Uganda to try any offense in the law books of Uganda. A question was put to the learned Attorney General on whether his trust, confidence, and belief. A question was put to the Attorney General on where his trust, confidence, and belief would lie in delivery of justice on the offenses proposed in the bill. Were those trials to take place premised on the same facts before either the civilian courts or the court-martial? So we have two sets of same offenses. Which of the two courts would the Attorney General trust? The learned Attorney General answered that both courts can and would deliver justice. The understanding of the minority on this answer is that the learned Attorney General confirmed that civilian courts in existence right now is capable of conducting any trial of criminal nature in Uganda without need to waste time and resources on the court-martial, which has unconstitutional structure. The structure, not the court-martial. The court-martial is constitutional, but its structure has unconstitutional structure, incapable of delivering a free, fair, and impartial justice to any accused person. Even, Madam Speaker, even if this answer is denied, the question to the government and the mover of the bill is the government of NRM in power for 39 years, and who virtually recruited and appointed all the cadres, the investigators, the police, the prosecutors, office of the DPP, the arbitrators, the judicial officers? If we check on the record of the current structure of police, leadership, and the rest, all of them have been recruited by this government. Are they therefore justified to complain on the incompetence, the weakness in the judicial system? The question is, the NRM government in power judicial system. The question is, the NRM government in power for 39, who recruited and appointed all the cadres in the justice system, the police, prosecutors, and the arbitrators, the judicial officers, are they justified to complain competence, weakness in the civil courts to handle any case in Uganda? If minority was granted more time, Right Honorable Speaker, it would have produced on all cases of murder, aggravated robberies, terrorism proposed in the bill, accused person, including military personnel, which has been successfully prosecuted in civilian courts. By the time of writing this report, Madam Speaker, I had known that yesterday the High Court convicted a former soldier, a militant, of an offense. That demonstrates and strengthens my argument that actually the civilian courts right now can convict murder, aggravated robbery, etc. Minority invites the attention of members, especially those familiar with papers, to reflect on the proposal of the Chief Justice, which captures it of the advisory order by the Chief Justice as follows. I'll put a heading there just to illustrate when we come to the amendment. All the headings of courts in Uganda would be written the Republic of Uganda. In the High Court of Uganda, it could be in Kamzampo, and in bracket, we put the provision for court-martial military division. That is what the learned Chief Justice had advised. The minority finds that the proposals in the Uganda People's Defense Forces Amendment, Bill 2025, purporting to recreate the court with unlimited original jurisdiction, is unconstitutional. It inadvertently amends Article 139 of the Constitution without following the procedure of amendment provided under Chapter 10 of the same Constitution. The minority further finds that administratively viable to provide for a specialized court within the courts for purpose of trial of criminal offences committed by the military person. The point of the dissent is on limited or exceptional circumstances. Madam Speaker, the minority recognizes the discussion, judgment on the limited circumstances of trials of civilians
military persons in the court martial in Uganda. In the judgment, the minority found that these circumstances appear to be strictly in reference to where, and we can pay attention. One, the constitution is not similar to the military rule during Idi Amin's regime. First condition for trial of civilians in the military court, there must not be constitutional. Two, courts of law have no capacity to try the offense. For example, there are shortages of competent judicial officers. Three, soldiers and civilians are duty or deployed in a foreign land where there is no possibility of return for trial in Uganda, and there is no other court in that country to try the accused. We all know where our army, the UPDF, are. So the court martials can try them there in case that country does all the situation of the war in that country. That is the understanding of the minority. Scenario of Karamoja, which was presented in the committee as a success story of the court martials, was unjustified. It was clear that judicial officers had feared to be deployed in Karamoja to years because of insecurity. These are the questions. Were other courts in the districts also unavailable to try those cases? Did the same government demonstrate Uganda courts in Karamoja were fully functional when Colonel retired Dr. Kiza Besigye was flown to Moroto and charged in the civilian courts? Who is mandated to ensure an order in Uganda? And why not deal with the root causes of it all, which is the security judicial officers, rather than recourse to the courts martial? Madams, were the trials free and fair in Karamoja? The presumption of innocence, were they read through them? Did they take proper plea? Did they give evidence as per the evidence? Was there a ruling on the prima facie case? Was there a defense? Were there actions? Did they allow them to plead to mitigate? And what was the sentencing guideline? In the opinion of the committee, it is foolish to legislate to provide for unconstitutional situations, leading for scenarios where the constitution laws are not enforced. All I am saying, government cannot sit and legislate for a situation where the constitution is not. It would be foolish of us that. And as such, to make
At least not every bullish.
no, I just said it is. I didn't accuse anybody. Right, Honorable Speaker, to make all Ugandans liable for trial in the military system. First, all Ugandans Madam Speaker, to make all Uganda liable for trial in the military justice system, first of
The search for Miss Uganda is back on Star Times Makula-Chika. All regions compete for one crown. Who will be the next true Ugandan beauty queen? Do you have the looks, the brains, the confidence? This is your chance. For registration, log on to www.missuganda.co.ug before 20th June. Miss Uganda 2025 premieres on 27th June at 8 p.m. on Makula-Chika. Stay connected on Star Times to watch the journey to the crown.
Miss Uganda, true Ugandan beauty.
This search is sponsored by Vian Esheri, Sino Mbale Industrial Park,
Home,
Xiaomi, and Tico Safari Lodge, and lead sponsor Tianao Furniture Manufacturing.
olina ekirooto ekyokulunda embuzi n'okwenyigira mu byobulimi ebikola n'okuzza amagoba osobwa aba YPA.
And we are going to host AFCON. We had requested, we have 1.15 billion.
AFCON has its money and for working on the services around.
oyagadde okujja okulaba General Isoke ojja jimpa omuntu oyo tujja kumunoonyereza oba bali bameka tulabe nga tutekinga action naddala bw'obanga otuyambye n'otufunira evidence.
Obubaka buno bukutuusibwako akakiiko mu maka g'omukulembeze w'eggwanga akalwanyisa enguzi aka State House Anti-Corruption Unit.